welcome everybody to today's webinar. We very much appreciate your joining us. My name is Lisa Ropel. As Michael mentioned, I'm a partner in Jones Day's Cybersecurity, Privacy, and Data Protection practice. I'm located in Boston, and I'm fortunate to be practice leader for our global cybersecurity, privacy, and data protection practice. This webinar is part of our team's continuing efforts to help keep you updated on significant developments in cyber and privacy law, which we all know is a huge lift, given how rapidly those laws are developing. We regularly provide hot topic briefings in which I know many in the audience participate, so thank you. Those are intended to highlight key developments and emerging risks very briefly. And additionally, we host webinars and podcasts on specific topics of particular complexity and risk. And that brings us to today's session. Today, we're going to be focusing on the legal challenges that companies face in trying to transfer personal data from the EU lawfully in the wake of Schrems 2. Now, that decision, you all know, which was issued actually a year to the date, pretty much today, 1 year ago, invalidated the US Privacy Shield, on which many companies have previously relied to transfer data from the EU to the US. Those companies now must rely on alternative transfer mechanisms such as SCCs. We're going to talk a lot about those today, but the decision has much broader impact because in the wake of Schrems, having SCCs in place no longer is sufficient alone. Companies now have to conduct a transfer impact assessment for each transfer. And this new requirement not only adds burden and expense for companies, but injects significant uncertainty and risk into the equation, especially in the case of transfers from the EU to the US, given that some DPAs have expressed skepticism about whether any data transfer to the US from EU of personal data could pass muster under a data transfer assessment unless the data are fully encrypted during the transit process and at rest when they land in the US. It's not always operationally realistic. Our James J team today is going to talk about how practically companies can go forward in the context that we find ourselves in, which is difficult and uncertain and fraught with risk. And we're very, very fortunate and honored to have with us today Michael Will, who's the president of the Bavarian DPA. My colleague Dina will introduce Michael a little bit more in a minute. I just wanted to thank Michael for participating and helping us understand the regulatory perspective on these issues. Before I turn it over to Undine, just a quick note on questions. We invite you to submit them. Please use the chat feature along the way. We hope to have time to answer some of the questions at the end, but based on my experience, the ambitious agenda and the enthusiasm of our team, I have to apologize in advance if we don't get to them. We will follow up with you after the webinar directly, so please don't hesitate to put them in there and we'll be in touch. We'll also at the end of the presentation display a slide that has contact information for all of the speakers you'll see today. Please reach out to any of us directly with any questions or for any additional information. And with that, I hand the mic over to Undina to start our program. Thanks, Undina.
Thanks so much, Lisa, and welcome also from my side to all participants of this webinar. As Lisa said, I would like to introduce to you our guest speaker, Michael Will, a little bit further. Michael is the president of the Bavarian Data Protection Authority. He has been appointed to this position for 5 years in last year. Michael Willi has had a distinguished career in public service in Bavaria. Most notably, he was appointed head of Data Protection Department at the Bavarian State Ministry of Interior in 2009. And on behalf of the German Bundesrat, he accompanied the entire negotiations of the Council Working Party on the GDPR from 2012 to 2015. So Michael really is in the position to share his views on data protection matters from a political perspective, and at the same time, as president of the Bavarian Data Protection Authority, of course, he's in charge of enforcement now, and this adds, I think, another interesting perspective on these issues. So Michael, again, thank you very much for being with us today. Let me start to give you a quick overview and introduction into the topics of today's discussions. As Lisa mentioned, 1 year ago, the Court of Justice of the European Union, as we all remember, invalidated the EU-US Privacy Shield. And this was mainly due to the reason that the court found that overly broad access to the data transferred happened in the US by public authorities. The court also observed a lack of redress to EU data subjects and a lack of oversight in this regard. At the same time, the court upheld the standard contractual clauses, the SCCs, but the court emphasized the need of a transfer impact assessment. And in fact, the court made it clear that a transfer impact assessment is not only required for SCCs, but for all transfer tools available under the GDPR, including, for example, BCRs. A transfer impact assessment is, as a short description, basically an assessment of the law and the practice in the third country, whether they impinge on the effectiveness of the safeguards that exist under the respective transfer tool. And if you come in the course of the transfer impact assessment to the result that this is not the case, the data can be transferred. If you come to the result that there is in fact some form of impingement, you have to further evaluate whether there are suitable additional measures available, such as Lisa mentioned, encryption, a measure of technical nature, or organizational or contractual measures. If you find that no suitable measures are existing, the transfer would have to stop. It's important that although we have now the new SCCs adopted by the EU Commission, that a transfer impact assessment still remains required. In fact, the SCCs expressly require the documentation of the transfer impact assessment, and they require to make the transfer impact assessment available to the data protection authorities upon their request. Under the SCCs, both parties, the data exporter and the data importer, even warrant that they have carried out a data protection impact assessment. In my view, the most critical point, however, of a transfer impact assessment is really to what extent parties can rely on the so-called risk-based approach. And we will also discuss this with Michael later on. So in other words, to what extent can the parties argue that there exists a low likelihood or no likelihood of access by public authorities to the data transferred? Interestingly, the EU Commission and the EU data protection authorities seem to differ, at least somewhat, in this regard. If you look closely at the new SCCs in footnote 12, it reads as if the risk-based approach is accepted under the SCCs. If you read the recommendations of the EU Data Protection Board, although they have removed in the final version their statement contained in the initial version that subjective factors such as the likelihood of public authority accessing the data should not be considered. But if you read the recommendations closely, it still is not clear, as Lisa mentioned, to what extent data can be transferred to the US when access to data in the clear is needed. If it's possible, in other words, to argue that, for example, for HR data transfer, there's only a low risk of access. At the same time, the EU data protection enforcement have kicked in enforcement activities. Just to name a few, the Bavarian Data Protection Authority had decided that the data transfer to a US newsletter provider is unlawful. The reason was basically that the data exporting company failed to carry out a data transfer impact assessment at all. Another interesting decision was issued by the Portuguese Data Protection Authority, which recently suspended the data flows to a cloud platform service provider in the US with immediate effect. And that was interestingly a data transfer by a public authority, by the National Institute of Statistics in Portugal. The European Data Protection Supervisor has launched investigations into the use of cloud services by EU institutions, including the European Commission's own use of Microsoft Office 365. And we will discuss this also with Michael. The German DPAs have actually started to send out questionnaires to randomly selected companies inquiring on their international data transfer practices, including their intercompany transfers of customers and employee data. Michael, we have spoken about enforcement, and of course, you as the president of one, I think, of the most relevant EU data protection authorities, which is competent for a number of DAX companies and subsidiaries of US companies, we are wondering what your authority is planning to do in order to enforce Schrems 2 requirements and what your expectation is in this regard. So in other words, what do you expect from companies when you inquire on their Schrems 2 compliance?
Thank you, Antine. Thanks to all for the invitation and for the opportunity to give some explanations. I will try my best, at least. I'm sure that I will not convince everyone, but I will try to explain. So let's start. At first point, I think you should know that we know that the Schrems 2 decision is a big challenge for the data processing practice. Even for us, it's not a simple question, something we have asked for to be allowed to do. The Schrems 2 decision is even for us a challenge, as we know that in fact it's a little bit contrary to our day-by-day practice. We know that European companies use in a large scale after all, US partners for data processing that we have very stable and strong relations in all kinds of commerce. So when we start enforcing the decision, we thought at first level about certain processing activities which should be replaceable, which shouldn't be vital for companies. So we send out questionnaires regarding newsletter services and other services which are as well used by American and other foreign partners, as well as in European companies. When doing this, our expectations are not too high. We are rather humble. At the first point, we want to see whether controllers have done a good analysis of their processing activities, as they should. After all, regarding the GDPR, when you look at the obligation to have a ROPA or something else. And then we are really curious to see how they managed the task to do the TIA, the impact assessment, because we know that's more or less a new obligation, even if it was written in the former SCCs. We know that, but it was not used in a large scale in practice. So we want to see how this process is solved, and at the end, we are very curious to see what solutions there will be developed by the data processing practice beyond those proposals we made in the EDPB recommendations, because we think that this is a common task, not only of us, of the data protection authorities, but also of processors and controllers. And we hope at last that there are other solutions beyond the 6 or 7 examples we have in our recommendations.
Thank you very much, Michael. That was very helpful. If I may ask a follow-up question, you mentioned that you are curious how companies will manage that task of conduct a transfer impact assessment. Do you have already any type of format in mind for a transfer impact assessment? I've just read an article where a colleague suggested, well, companies could in fact lean on to the format of the questionnaires that the German data protection authorities have sent out on various types of data transfers and could answer them properly, and that would make a proper transfer impact assessment. I personally have to say I have my doubts in this regard, because obviously these questionnaires do not address very pertinent points, like, for example, what types of laws are relevant in the data importer country, and they also do not really address the practice of access in the third country. So is there any type or format for transfer impact assessment that you currently find suitable or would recommend?
No, not yet. I would be happy if at the end of the process of the sending out of the questionnaires, we would have some more or less best practice examples. Right now, we don't have, and I completely agree with you. Our questionnaire is only the key structure of a TEA, not the sole questions you have to give answers to. That would be, I think, a severe misunderstanding.
And I hope you don't mind, but and I certainly don't want to put you on the spot, but with regard to the risk-based approach, I guess we are all waiting for some kind of enlightenment where yeah, the EU data protection authorities are sort of leaning to. So I touched a little bit upon this sort of possible difference in opinion between the Commission and the European Data Protection Board in terms of whether the risk-based approach is suitable in the transfer impact assessment. But maybe this is a misunderstanding, and maybe I'm too critical in my reading of the final version of the recommendations. So what is your take? Is it suitable in a transfer impact assessment to make the argument that there's in fact no risk or no risk of access to a certain type of data transferred, especially to the US?
As always, when talking to you, Undine, I think your analyses are very clear and very attentive. I think there is indeed a slight difference between the perspective of the European Commission and the perspective of the EDPB, at least the majority of the EDPB. Just I'm not able to give you this afternoon any good news about acknowledging the risk-based approach as a principle for doing TIA. I'm not able to do this, and I'm not able because I have on the other side a very clear judgment of the European Court of Justice, which tells me what I have to look at. I have to look, when assessing the adequacy of a third country, its conditions in its law. I'm not allowed to only look at the practice. And personally, in former times, I had worked with entities which are responsible for security questions in Bavaria. I don't think that we only can judge the situation and the risk for privacy we have when looking at the actual times the actual practice of security entities, of offices, because situations may change. There may be new threats, and then these agencies have to ask themselves, is the law we have enough to challenge these new threats, to do our enforcement activities as we have to do to ensure security for a country. So I don't think that it's useful to only look at the practice we have right now. You have at first to look at the law, and the risk-based approach may be suitable if you look at the measures you do. It may be suitable to have a judgment where the kind of encryption you have may be enough to ensure the integrity and security of your data.
Okay, thank you very much, Michael. I think we got the message. It stays complicated.
It stays complicated, yes.
Jörg, Olivier, on that note, we have now heard so much about transfer impact assessments and as a cornerstone, I guess, of Schrems 2 compliance. Can you please go a little bit into more detail what you recommend as main contents of transfer impact assessments and how to practically document that a transfer impact assessment has been conducted?
Yeah, sure, Andina, and I think I'm very happy to hear that Michael also doesn't have the silver bullet right now for that situation. So, and we have looked at many different papers, the guidelines, the recommendations, of course. What should be the content? How do you document? Where's the guidance available? And there's a lot of pages to go through, right? I mean, there's like 50 pages recommendations, almost 30 pages SCCs. That's a lot of pages to go through. And so when we looked at that, I'm happy to share some experience here today with you, of course, on this issue. So how do you do this properly in terms of the transfer impact assessment, TIA? I think what is probably a fair statement at this point in time, there's no one-size-fits-all approach, right? It really depends on the type of company we're looking at, type of organization, the size, the business model, what are the processing activities, what kind of data is involved, right? Data transfer activities. So this is very important to recognize, right? So even though you may be able to develop certain tools and templates and maybe a starting point, you will still have to look at your company and your business model and see the types of data involved to develop an impact assessment that's appropriate in our view. So Olivier, I spent some time looking at, what's the recurring message, right? By the authorities, by regulators, DPAs, such as Michael will and others in Europe, right? Not just Germany. And what do they want to see, right? What is the practical approach to this? And also, what is the expectation by the European Commission, right? The legislator with the SCCs, for example. So there's 4 elements that we found. You can see it on the slide right here. Number 1 is, of course, description of data transfers, right? You can't come up with a proper assessment if you have no idea what the data is, where the data is going, right? In terms of your transfer activities within a group of companies or to third parties, it's the same thing, and to which countries and so on. So that's the first big element to make sure that you have that on your checklist. Number 2 is, as Undina already explained previously, the assessment of the third country framework, right? And we will hear more about in a minute. So we're looking at the legal framework that's out there, where the data is received by an organization. Number 3 then would be looking at the appropriate data transfer tool, SCCs, BCRs, derogations, Article 49. You have to probably look at all of them to make a proper assessment, right? And then last but not least, you have to identify risk. And we will talk about that in a minute as well, to have a conclusion, as Undina alluded to, what is actually the way forward after you made the assessment. So, and I think, Olivier, why don't you tell us a bit more detail about these 4 cornerstones for the TIA?
Sure, you're happy to do so. So first cornerstone would be the description of the data transfers. Indeed, this is one of the cornerstones of the transfer impact assessment exercise, because data mapping will allow the exporter to know the specifics of the data processing activity and the related transfer. And in particular, what should be documented is the length of the processing chain, including the transmission channels involved. Also identify the subcontractors involved and the possible onward transfers that will be involved. That's a very crucial point, because obviously you don't just want to assess the legal framework applicable to the first importer, but also include in your assessment the whole chain of recipients. Also, obviously, you have to include in your mapping exercise the types of recipients and purpose of processing, and not forget the categories and format of the transfer data. The second cornerstone is obviously the assessment of the legal framework that's applicable in the destination country. And this legal framework has to be assessed in regard of the European essential guarantees for data protection. And in particular, it should be documented in your transfer impact assessment whether the legal rules applicable in the destination country are clear, precise, and accessible, whether they're necessary and proportionate with respect to legitimate objective pursuit, if there is an independent oversight mechanism, and effective remedies for the individuals. And what should be noted also is that it's not a whole assessment for all the legal sectors and types of activities available in the destination country. Obviously, that should be focused on the specific transfer that relates to your data processing activity at stake. A third pillar of the transfer impact assessment would be in the event that the legislation in the destination country is problematic, you should envisage supplementary measures as identified by the Schrems 2 ruling of the European Court of Justice. And as you know, these could be either contractual measures, technical measures, or organizational measures. But as noted in a certain number of documents and opinions and analyses, it's probably the technical measures that may have the highest degree of efficiency to avoid any impingement by the legal framework in destination country over the protections offered by the data transfer safeguards that are implemented. And once you've documented, I'd say, the three pillars that we just mentioned, then you should come to a conclusion and, if required and possible, decide to implement effective supplementary measures and then proceed to the transfer. Or in certain specific cases, you may also come to the conclusion that it's possible to implement the data transfers that you envisage without any supplementary measures, but only if it is considered that there are no reasons to believe that the relevant and problematic elements of the legislation in the destination country will be applied to the importer. So in a way, you have to document what the real practice is in the destination country, but to a certain extent, that's my take on the elements available for now, is that you cannot really take a risk on the application or not. You should probably not transfer data if you believe there is a low risk, and at least that's what seems to appear from the elements available.
Thank you very much. Just a quick question on documentation of the transfer impact assessment. How would you recommend, really practically speaking, should companies document the transfer impact assessment? I mean, I have heard from companies that they try to combine it with the records of processing somehow. Is that a suitable approach? How would you recommend doing this?
Well, I would tend to recommend to document it separately. I think, well, the record already needs to include a number of elements that are required by GDPR. So now we have this additional requirement, and the transfer impact assessment, as you mentioned, definitely needs to be documented. That's one of the key obligations of accountability pursuant to GDPR. But there's, as we just mentioned, there's a number of elements that should be included in that analysis. That is a specific transfer analysis. And as Jörg mentioned, there's no one-size-fits-all analysis. So I would tend to say that should be a separate analysis And as Jorg will explain, it's probably a separate document that should be provided. I mean, that the exporter should be ready to provide to a DPA in case of an inquiry.
Yeah, I think that's a very good point, and especially for this reason, it should be a separate document. So not such a good idea to do it together with the records of processing, I think. Coming to the US part of things, so to speak, I mentioned initially that the main reason for invalidation of the EU-US Privacy Shield was that the court perceived an overly broad access to the data transferred by US public authorities. And the court mentioned FISA 702 and EO 12333 expressly in this regard. We are very fortunate to have our colleague Skylar Felton from our Washington, D.C. office with us to explain a little bit further the scope of these provisions. And I think, Skylar, you really have hands-on experience in this regard because you actually have worked in the administration on matters of this nature.
Yes, thank you, Indina. It's a pleasure to join you, and thank you again to our distinguished guest, Michael Will. It's a pleasure to be here with you and to hear your views on these issues. In the Schrems 2 decision, the court focused on what the referring court had described as mass and indiscriminate processing of personal data. Without taking on that characterization or evaluating it specifically on its own terms, I do think it's useful for the assessments and the evaluations that we're discussing today to focus a bit on the two main authorities that the court cited as the basis for its decision and its characterization there. First, as you mentioned, is Section 702 of the Foreign Intelligence Surveillance Act, FISA Section 702. The other is Executive Order 12333, 12333, as amended. These authorities each have characteristic authorizations. They're government law. They had been I would say a somewhat esoteric corner of the law until the Schrems 2 decision obliged lawyers on both sides of the Atlantic to reach for their law book and review these authorities, often for the first time, and assess how they might apply to various private parties and data transfers. I'll characterize a few aspects of each, though with the caveat that these are, of course, very complex bodies of law and practice, and the evaluation of each, particularly in the context we're talking about today, is necessarily going to be fact-specific. So this is a general overview for the purpose of laying out some of the building blocks for these analyses. FISA Section 702 is a statutory authority. This derives from a bill passed by Congress, enacted into law. Underlying statute comes from the 1970s. It's been amended in the early 2000s, in relevant part here. It provides or it establishes a process for the United States government to select authorized targets for surveillance, to certify its targeting practices to a foreign intelligence surveillance court composed of Senate-confirmed federal judges, to request relevant communications from US-based electronic communication service providers, and for the service providers, in fact, to contest these requests. So it's a statute that establishes a process. It is focused on a certain body of authorized targets and certain types of actors in communications. So in this sense, we can say it covers communications of non-US persons reasonably believed to be located outside the United States. And it applies in the sense of creating an authorization for the government to impose an obligation or issue a request to. It applies to US-based electronic communication service providers. Now, this latter point suggests that a person preparing a transfer impact assessment should assess whether they are such a communication service provider or whether they will be dealing with one. Courts have defined electronic communication service providers to include telecommunications companies, as well as entities that provide email, instant messaging, or other communication services. And in the body of interpretation in this field, at least as applied in US courts, it is possible to be an electronic communication service provider for the purposes of certain communications and bodies of data, but not others. So a company may itself be an electronic communication service provider if it provides certain services to its employees, some courts have found. But of course, the main set of parties here tend to be the mainstream communication service providers as they're commonly understood in this field. That's a very brief overview of FISA 702. It is mentioned alongside, interspersed with discussion of EO 12333 in the Schrems 2 decision. EO 12, that is Executive Order 12333, is a rather different kind of authority. It is not a statute, but rather a presidential directive. And it is primarily focused on, it directs and authorizes activity by government agencies. So it is binding on and applies directly to the heads of government agencies. It's particularly focused on what the order calls the United States intelligence effort. Unlike FISA Section 702, EO 12333 does not create a process that would be directly binding on a private party. So the private or regulated parties are in a rather different position with respect to this executive order. Executive Order 12333 exists. It's a significant authority in the body of United States government law and practice, but most of its practice and interpretation happens within the government as agencies determine what they're authorized to do under the order. This executive order was issued by President Reagan. It has been amended in turn by Presidents Bush and Obama. It still retains its original number in common parlance, 12333. It focuses on or covers a range of issues with a particular focus on foreign threats to the United States as the United States government assesses them. It refers to the collection of information concerning intelligence activities directed against the United States, international terrorist and international narcotics activities, and other hostile activities directed against the United States by foreign powers, organizations, persons, and their agents. Now, as I mentioned, the order's authorizations and provisions are primarily, even exclusively, focused on what government agencies are meant to do to collect information on those threats. And if one reads the order, this is a public document, though much of the practice under it is not publicly discussed or publicly available. The order itself makes quite clear, and the underlying statutory authorities for these agencies also make clear, that the focus of the information collection efforts under 12333 are focused outside the United States. And this is a topic that one could spend hours discussing. We don't have those hours, but this is a point that the government takes quite seriously. It raises the somewhat counterintuitive question in connection with the Schrems 2 decision, whether with respect to Executive Order 12333, the safest place for data in connection with the considerations that the court posed, whether that is in fact inside the United States, because this focuses on government authorities that are really focused outward. So this is a very, it's an intricate and complex body of authorities. These are areas that are complex on their face and made more so by the fact that the United States government, under its own procedures, tends not to advertise all of the details of what it does or what it aims to do. But there are in each of these authorities and in the department and agency guidance documents or explanations and congressional testimony issued in connection with them, there are blueprints there available for companies and other private actors to understand what it is the United States government is focused on, what precautions it takes, what it is authorized to do and what not authorized to do. And I think in that respect, although we all have, as lawyers and regulated parties, we all have a rather complex task before us, there are answers and building blocks available. So it is a task worth pursuing and authorities worth reviewing. Thank you for the opportunity to share a brief summary.
Thank you very much, Skylar. This was very enlightening. I saw a little smile on Michael Will's face when, and I hope I'm not misinterpreting this, when you mentioned the fact that FISA 702 could in fact apply to a company in its role as providing email services to its employees. From a German perspective, I think we are smiling a little bit about this because we apply telecommunication secrecy law under these circumstances. And so far, I only thought we were the only country coming up with an idea of this sort. So perhaps as a follow-up question, Skylar, did I understand this interpretation and possible scope of FISA 702 correctly? And the other question is, I think the EU data protection authorities have mentioned this also in their recommendations. FISA 702 is usually applied also to cloud computing providers. Is that in its breadth a correct statement?
There's support for both of these interpretations. There may be varying degrees of practice in real life, although I take the point of our guest that practice is different from authorization. But on the first point, there is a body of interpretations of the phrase electronic communication service provider that can be read to apply this term to a company in its capacity as a service provider to its own employees.
And with regard to cloud computing providers, is it correct that FISA 702 applies to US-based cloud providers?
As a matter of law and legal interpretation, that's generally the more straightforward view.
Mm-hmm. So Michael, do you have I know that the EU data protection authorities also have done their own analysis of these provisions. Do you have an immediate reaction to what Skylar just presented?
Yes, immediate reactions. Give me more time. We need at least
fair point. Sorry for putting you on the spot here.
2 or 3 hours, please. So the interesting remark of Skylar was that he said, when I understood it properly, that all these instruments for the surveillance authorities are focused on the world outside the US, that there are much stronger data protection frameworks when we look at data which is located in the US. Is it a too simple, in a short version of that what you said, Skylar?
No, I agree with your characterization, but I don't think it's simple. I think it poses an almost paradoxical question in connection with the Schrems II decision.
Yes, and this is why I want to come back to it, because we have to keep in mind that the key question we are now dealing with is whether the importer is, by reasons of law, not able to comply with the obligations laid down in the SCCs. So I'm asking myself, when data is already transferred to the US, when it's used in the US, for example, by a company which is part of an international group, what would be the TIA regarding section 702 of FISA? When I understood your analysis properly, this company has no problem with the possibilities that FISA offers for US surveillance authorities.
I hesitate to say on a live webinar that any party has no problem with respect to a particular law.
Okay.
I would like to make sure I understand your example better before saying whether I agree or disagree.
Yeah, there's just like one core matter of the whole tier is to look very precisely on your processing activity. So let's look, for instance, at the processing activity of HR data, which is transferred from a European company to its US mother, and there are persons who deal with its HR data to decide whether they should have another job or something else. And now, when I should do the tier for this kind of processing activity, what would be your result regarding these two pieces of laws, the FISA Section 702 and the Executive Order 12333?
A transfer from a European office to a US office?
From a European company to its US mother.
I see.
Just to make it short, I think the problem will be more or less the transfer of data, the data in transit, when it is the way to come to the US. But your analysis told me that once it is in the US, it starts there. We have to look at other to look at other laws than the Section 702 of FISA to assess the risk, whether the importer is able to comply with the SCCs.
Well, is the HR data of US person employees?
No, it's mixed. It's European data and it's US data too, of US employees. So we have, at the end, to make it simple, European data you have received, European employees data.
In that case, I think it would be rather relevant that the mother company, as you put it, is a US company and likely to be a US person. There would be also US person data within the HR files. So I think that there would be a fair amount of protection. That is, a fair amount of this would be off limits from authorized collection requests or surveillance requests. But I would imagine there would be various nuances here that would be worth taking into account. And I don't wish to give the impression that I'm giving sort of an off-the-cuff complete answer on this webinar.
Of course not. No.
No. What I just wanted to show for us all is how difficult the questions are. So there is no one-size-fits-all answer, even when we are looking at this very well-analyzed US laws, when some people say, oh, so it's a US transfer, and so that what the ECJ said, and he said that Section 702 of FISA is not in line with European data protection principles. That is not the whole answer at the end.
Yeah, that is a very important point to stress. I think coming from the scope of US surveillance laws to the most used transfer mechanism, the SCCs, I think in the minutes left, it would be very helpful if you, Jörg and Olivier, could tell us about what is new in the new SCCs, and particularly also including the transfer impact assessment that we have discussed so much in the course of this webinar.
Yeah, sure, Nina. And indeed, in the wake of all this guidance and questions in relation to transfer impact assessments, as well, most of you know, there's been a new set of standard contractual clauses that has been just released in June, and that takes into account the issue of the legal framework in the destination country. But nevertheless, there's a number of fundamental points that should still be taken care of when implementing standard contractual clauses as appropriate safeguards for transferring personal data. First point, as we mentioned, is that obviously the exporter should carefully map the international data transfers that are contemplated in order to carry out the transfer impact assessment. And also, one specific point of the new set of clauses is that it's very modular. It contemplates 4 different scenarios, and in particular, 2 new scenarios with the modules 3 and 4, which not only now address controller to controller or controller to processor transfers, but also the situations where the exporter is a processor, and therefore module 3 relates to the transfer between an exporter that is a processor to an importer that also acts as a processor, and module 4 will address the transfer by a processor to a controller. So these are very powerful and new tools that are very useful to address situations which the old sets of clauses could not properly address, and for which we had to use complex mechanisms of powers of attorney. But hopefully the new sets of clauses have these new possibilities, subject obviously to carrying out the preliminary analysis of what the roles of the exporter and the exporting parties are. And the third point, obviously, is really to, and that's also in connection with the initial mapping of the transfers, is to carefully identify the parties involved. And as we mentioned previously, not just take a look at the initial recipient in the destination country, but to take a look at the whole chain of subcontractors and possible onward transfers, because that will be key for assessing whether the legal framework in the destination countries is suitable for the implementation of the standard contractual clause or may impinge of the protections afforded.
Yeah, and then we have, as you see on the slides, just real quick to give you a complete picture, because you got to start somewhere, right, in practice, even though I think it's a fantastic discussion that we just heard between Michael and Skylar. This is now the next step, supplementary measures. This is where, these 3 options kick in. What do you do if you identify there is risk for potential law enforcement access? And what do you do in practice? So you have to look at these 3 points. Last but not least, you have to address formal procedural requirements, docking clause and like in the SCCs. And last but not least, should evaluate the arrangements, right, in a regular time frame. I want to just add quickly that the European Commission is working on FAQ that's going to be published to, further help provide guidance to companies how to implement SCCs. And I think we're still hearing on the UK, right, Ondina?
That is very true, Jörg. And here we have the UK perspective. Jonathan, if you don't mind to give us an insight how the UK, for example, perceives the new SCCs. Can I use them for transfers from the UK?
Sure, and the part of my Brexit in 1 minute series. Brexit, this has come at the last minute, but we have solved the problem, which was how to ensure data transfers from Europe to the UK were not interrupted. And in the line with both sides' political positions, this has been done on a reciprocal recognition of each other's standards. So that is the good news. The UK now has an adequacy decision. Insofar as the transfer rules, the UK will allow use of the old EU SCCs. So you can do that during the grace period, but not the new ones. Reason being that the UK authority is consulting over new UK versions over the summer. So that means if you're doing a global mechanism, you probably have an awkward period where the UK can't go straight to the new modular approach. In terms of going forward, we need to keep a watching brief. The adequacy decision has a 4-year sunset provision. The EU will watch what we do with our rules. They can intervene if we depart in the interim. And the UK has said it will keep the EU position on adequacy and SCCs under review. If you're looking for potential issues, we know there is some unease on the European side about the UK surveillance rules and how those will evolve. That maybe is a potential cause of friction going forward. And also the Prime Minister commissioned the ominously named TIGA, the Task Force on Innovation, Growth and Regulatory Reform, which looked at some of the regulatory opportunities of leaving the EU and made some rather harsh criticisms of GDPR. So potentially on the UK side, if there is a political move to vary some of these things, then that perhaps will call the adequacy position into some doubt. But we have solved the immediate problem. Thanks, Undine.
Thank you very much, Jonathan. Very last question. Hearing all this and considering that we had Privacy Shield as a very helpful and practical transfer tool, how do you assess the chances, Michael and Skylar, that we might have a Privacy Shield 2.0 in the future? Michael, do you want to start?
Yes, I try to start, and I give you an optimistic end of the discussion. They should try to, because it's important and would help, after all, the SMEs to relieve them from very complicated questions, and I'm sure that they will try their best.
So, Skylar, do you share this optimistic outlook?
I do. I think it's a complex task, but there's a lot of will to work on it. Certainly from the United States side, it's something that regulators want, that the Biden administration will I think, support and search for quite earnestly, and certainly that industry wants. So it's a complicated road, but I think from the US side, many of the key players will be quite committed to finding a way forward on this.
Thank you very much. Thank you to all speakers. Thank you to all participants. You see our contacts here. We are very happy to address your questions following this webinar, and of course stand ready for further discussions. It was our pleasure. Thank you.